In today's video, we're going to talk about how to pick a guardian for your children. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like today's video, hit that like and subscribe button. It actually really helps support the channel. Also, two caveats before we get going. First, I am not giving legal advice. This is for educational purposes only. And second, we're going to be focusing on Minnesota law. So if you live in another jurisdiction, you might pick something up from this. That's great. But be sure to talk to a practitioner in your jurisdiction before you go ahead and plan your estate. So picking a guardian tends to be one of the most difficult decisions my clients have when they're doing their estate plan. And to be specific, picking a guardian to raise their minor children if something happens to all of the parents before the child reaches the age of 18, the age of majority. Now, let's start with if you don't do anything. If you don't do anything, there's going to be a lot of court involvement. This is going to be expensive. It's going to be time consuming. It's going to be a real headache during a time that the children are already going through a very difficult set of circumstances. They're losing or have lost their parent. The court is going to do their best to find out what is in the best interests of the children, but they don't have your guidance as to what that might be and what your preferences might be, and what the court thinks is in the best interests of your children might not be what you think is in the best interests of your children. In order to avoid this situation and involving attorneys, involving social services, involving the courts to the extent that you would have to, you're going to always involve the courts. But if you can plan ahead, you can reduce that court involvement substantially. We're going to look at two time periods. First is when one parent is deceased, incapacitated, or unable to act as a parent, such as if they're in jail or if they're kidnapped, and the other parent is incapacitated but alive. The second time is when all parents for the child are dead. So we have a temporary situation where a parent could regain capacity or eventually die, and then we move to the permanent situation where all parents are deceased and we're looking to raise a child to the age of majority. And these are two very different things with two very different goals. Let's start with the temporary guardianship, sometimes called appointment of a standby custodian or a temporary guardian. I just call them guardianship directives. This is a document that will identify your nominations to be parent of the child in case of your incapacity. Two goals here. One is the continuation of life of the child, as to keep it as normal as possible, keep them going to the same school, seeing the same friends, being part of the same support network as possible. And second is giving them access to their incapacitated parent. If their parent is in a medical coma and somebody else is taking care of them, that child will probably want to see their parent in the hospital. In order to facilitate these two goals, we're going to look at four primary factors. First is familiarity of the guardian with the child, the guardian nominee with the child. We want that to be a close familiarity. We want them to like each other. It's a very difficult time for the child, where the child feels that things are just all up in the air. What if their parent dies? What if they, I guess that's the big one. What's going to happen to them? Where are they going to go if it becomes a permanent situation? The second thing, look for caring individuals. Now, this is maybe not the most intuitive one, but again, the child just hit a major shock of their parent becoming incapacitated. You need to have someone that is emotionally competent enough to be able to deal with that. Third, geographically nearby. Yes, shipping your kids off to Auntie Susie over in New Jersey might be best in the long term, but allowing the child to keep going to their same school, seeing their same friends, being part of the same support network, being able to access their parent in the hospital, those are all very important during this time. And finally, financially stable. Now, on the one hand, if you watch my videos, you know that if all parents are alive but incapacitated, or the single parent is alive but incapacitated, then a durable power of attorney in a will-based plan will have access to the funds and be able to funnel those to the guardian to make sure that the child can have their health, education, and maintenance and support financed during that time of incapacity. Or if you have a trust-based plan, your successor trustee will be able to do the same thing. Now, that said, on the other hand, there's a lot of bureaucracy with money going back and forth, making sure we got the durable power of attorney right, et cetera, et cetera. And the guardian is probably going to have to make a major change to their life. They're going to have to take time off work to go with the child to a psychiatrist, to help the child deal with things. For if they have problems in school, they may have to come off work and help them in that sense. If they're working, if the guardian is working 2 jobs and is busy 80 hours a week, that's a problem. We need someone that can be attentive to the needs of the child. Now, for permanent placement, we're going to do this effectively through a will. If you have a revocable living trust-based plan, you're going to do it through the pour-over will. Or you can do it in a guardianship directive. I do highly recommend that people make the nomination in their will, because that tends to be the controlling document that really people look to. The goals are very simple. We want the child to be raised right. Yes, we want the child to have as normal a life as possible moving forward and to be as psychologically stable as possible, but really we're looking to raise the child right. And for this, we're going to look at 3 factors. First is values. Second is capacity of the guardian. And third is relation to the family. Now, for values, this could be anything that you want to make sure that the guardian has. Do they have the same parenting philosophy of you, discipline style of you? What about just values? Is one of the most important things that you have an environmentally friendly household? Do you want to instill that to your children? Will the guardian instill that to their children? Sometimes people have dietary choices that they want their child to be raised vegan or vegetarian or not. Religious preferences, huge. If you want your child to be raised Catholic, for example, you might want to consider sending them to a Catholic family. The second factor category is going to be capacity. This is going to be, again, financial capacity. Yes, if it's set up properly, your child will have a trust that is funded, that will be used to support them until the age of majority, and then probably a few years after that. Yes, oftentimes those funds can be used for ancillary benefit for the child, but it's a major disruption for the life of the guardian. Along those lines is capacity to be a parent. If the guardian has never raised children, that might be a red flag. If the guardian already has 5 children of their own, that might be another red flag as well. Can they raise your children, your child or children, multiple children, to the age of majority? And the last one, and this is a really important one that a lot of people overlook, age. If we're looking at a temporary situation, grandma might be the perfect fit. She knows the kid. She's probably babysat or maybe did daycare for the kid, may live nearby. It might be a perfect fit for a temporary situation. But if grandma is 72 when your son or daughter is aged 2, when your son or daughter turns 18, if I did the math right, your grandma is going to be 88. An 88-year-old raising a teenager is not really a viable way to go about things. So while grandma might be perfect or grandpa might be perfect in the short term, in the long term, you're going to want to find somebody that is a bit younger. The last category is very simply family. Is it important for your child to maintain relationships with your family? If you live in Minnesota and all your family lives in Minnesota, except for that Aunt Susan that lives in Jersey. Aunt Susan would be great to raise the child, except, if you ship them over to Aunt Susan, they're probably never going to see their family or develop those close relationships with their family. That's something to consider if you want them to maintain relationships with their family. Picking a guardian is an incredibly important, but also incredibly difficult decision for many people to make, but it is vitally important to do it. Take the time, go through the factors, look at what to consider, what's important to you, and make that decision. And just make sure to make that decision and do some planning ahead of time. I hope you liked today's video. If you liked today's video, hit that like and subscribe. It helps support the channel. We do a new video every other Wednesday. If you have any questions or thoughts about what you think would be important for a guardian when picking a guardian, put them in the comments below or just send me a quick email. I'd love to see it. Otherwise, until next time, this is Gregory Singleton with Signature Law.